Hi, my name is Larry Newman. I'm an attorney in upstate New York. Our practice handles criminal defense and DWI. Today I want to talk to you about a recent case that illustrates facial sufficiency. You know, people call and they have questions. What's prima facie case? What's facial sufficiency? What's facially insufficient? I know, these are all legal terms. Basically, if they're going to charge you with a crime, they can charge you one of two ways. They can either charge you with a complaint or they can charge you with an information. And they're very similar. But to prosecute you, they must prosecute you by an information. And an information has to have two things in it. It has to have facts that are evidence, not conclusions, evidence. And it has to show that you're the person that committed the crime that they're charging you with. But what does that mean? Facts that are evidence, that are not hearsay, that are going to allege that you committed this offense. Well, People versus Toro is a great case because it illustrates exactly what facial sufficiency is and isn't. So in Toro, a person, a guy, hit a girl and the phone that was in her hand fell out of her hand, went to the floor and broke. So they charged Mr. Toro with two things. They charged him with violation of harassment in the second for hitting her, and they charged him with criminal mischief as a misdemeanor for breaking the phone. But for criminal mischief, a misdemeanor, you have to make out facts in the criminal information that show that he had the intent to damage the phone or to damage the property. Criminal mischief is a property crime. It means you have an intent. Normally we see it when someone goes and slashes somebody's tires or keys up somebody's car or takes something of somebody's and throws it. I mean, some people might grab your cell phone and take it and throw it and break it. That all those facts and show that you intended to cause the damage to their property. Mr. Turo only intended to hit this person, to strike her in the face. He didn't have any intention of breaking the phone. In fact, so the criminal information didn't contain these facts. And on appeal, see, the first lawyer didn't catch it, but the second lawyer did. After Mr. was already in jail, they appealed the misdemeanor for being facially insufficient because there weren't facts there that showed that Mr. Turo had the intent to break the phone, and that charge was thrown out. But Mr. Turo was already in jail for 20 days. So they figured it was like a wash because the most he would have gotten on the harassment charge was 15 days. And truthfully, he would have got 10 on that if it was a good time. So facial sufficiency means that there should be facts in the complaint that make out the charge. Each charge has elements. Sometimes a charge has intent in it. Sometimes a charge may have, like disorderly conduct, public annoyance in it. If you didn't annoy the public, what if you did something and there was nobody around? Then you can't have that charge. Same thing with moving from a lane unsafely. You need to have other cars around to move from a lane unsafely. Otherwise, if there's no other cars around, you can't do it. It's impossible to move from a lane unsafely if there's no other cars around. That's the truth of that. So they have to show that there's something around you that you're doing that's unsafe. If you have a question about your criminal complaint, criminal information in the upstate region, you have charges, these are the types of things that we handle. Either give us a call, shoot us an email, fill out the form on our website. Be more than happy to discuss it with you. And thanks for watching this video.